Frank knows and Molly knows, being a public defender, they say you can be told so many things, like you're not a real lawyer, I have shoes older than you, you're a child, go back where you came from, like, you know, all of that. So you just have to continue to do your job. But that one I found interesting because I have a man's last name, so like a last name that's like a man's first name.
I did not expect that example, but it's a really good one.
Yeah.
It's a really good one. Anybody else?
Yes.
Well, I just wanted to make a comment on what she said. I find that we're coming from a client in that scenario to be like almost expected. I find it more disappointing and disheartening when it comes from a colleague, someone that you're peer with. That's my only comment.
No, I think that was what we were expecting, more alignment to hear it. But but to the point of both of you, it exists everywhere. And it's not just unique to the law. I mean, obviously, it's not just unique to our profession, it's every profession. Any other experiences, thoughts, concerns? Karen, I already talked to you because you called me a jerk, so I'm going to call the person behind you.
Hi, my name's Umi, but it's not my full name, and I'm not going to go into my full name because it's very long. However, I'm still in law school, so professors see my full name on rosters and things. And I'm going to my JD, but the automatic assumption is always that I'm either an LLM or some other form of international student because I have a very clearly ethnic name. And furthermore, a lot of professors, when they see my name, tend to get a little frustrated. It's visible, they probably don't mean to, because it's long and it's hard to pronounce. And their automatic assumption is, oh, she has a shortened version of her name, which I do, but not everyone does.
Right. And it did cause any consternation between you and professors, or?
They started swearing before when they see the full name.
Swear.
So, yes.
I don't think Jim Smith's was planning on swearing.
I don't know, next scene.
Interesting. How about maybe, I saw your hand up as well.
Yeah, so I work in the Washington County Court of Common Pleas, and I'm the PFA coordinator, which is the law clerk that deals solely with PFAs. And the law clerk before me was also a woman. I don't think a man has ever had the position. And I've been working there for 6 months, and some guy, a sheriff, said to me the other day, "Are you the new PFA girl?" And they also confused me with the last girl, who is a 6-foot black woman. And it was very concerning. That they're like, "Oh, you've been here for over a year?" I'm like, "No."
Interesting. Sharon?
Yeah, I'm Sharon Lopez, and back when I was a younger attorney and practicing at legal services, we've got a lot of the whole, are you a real attorney from our clients, but having it come from a colleague, I had a colleague one day where I was called to an emergency. I didn't have a jacket, I had a sweater, but I had a skirt on. I had, looked professional enough, I thought. And he looks me up and down, and he says, "Are you a real attorney? Like, why should I even be talking to you?" He actually said that to my face. And when I saw you playing that role of that, as you characterize it, nice guy who was saying the wrong things, it reminded me of him. And I didn't think he was such a nice guy. I don't know that the intent of being helpful was what I registered, or maybe that's your acting, I don't know. But I think in particular in the legal profession, opposing counsel is sort of set up to throw you off guard. And it's a foul when you use a physically immutable characteristic or a bias like that as a means of throwing you off. It's one thing to throw you off by objecting to the form of the question. It's another thing to throw you off by saying, "Look, girly, someday you'll learn." That's a different thing.
To your point about perception of what I was saying, while I may not have been intending to be a jerk, I think to your point, it doesn't really matter how I intend it.
Right.
At the end of the day, it matters what's on the other side, and that's why, Don had said before, you need to think about, make sure your mindset, if you will, doesn't control your actions, especially when you're in a professional setting. Again, my acting aside, you took it. I didn't intend it that way, but you took it that way.
I took it that way.
Jordan took it that way.
Yeah,
Carrie very clearly took it that way. So
I think the young lady, we were talking about this earlier, young lady, that set the tone. And if I was in a real deposition, I would have been like claws out probably at that point, because I just would have been really pushed back.
Exactly.
Yeah.
Jordan, have you ever corrected someone who called you young lady?
Yes, numerous times. I get called that I own my own company, so usually when I walk in the door, there's a lot of shocked faces, and so I get called out all the time, and I constantly have to say, well, I'm also owning the company, so you either work with me or you don't work with us, you know, and that young lady thing, whew, I can't even go into it.
Do you say something specifically to young lady?
Yes, usually. I mean, usually what happens for me personally where I see this, my name is Jordan. If you have not done your research on me and I walk in, I have numerous times had potential clients, strategic partners, law firms we partner with, for 5 to 10 minutes repeatedly say, you're a woman. You're a woman, also a 6 foot tall woman. You're a tall woman, right? I've had this happen numerous times with my name is Jordan. So sometimes I just have to get them over the hurdle that I'm a woman, and then we can go on to that I'm a young woman. So, and usually I go, I think we've established that. So we could continue the conversation. You try to make light of it, right? And I had this conversation, ironically, in a setting a couple weeks ago, and the advice I was given was that as a woman, you have to take it graciously and do it with a smile and, and be nice about it, because if you're too abrupt, what are we called, right? Right. So, and that's hard. It's hard to stop it, and most times they're people that I'm trying to work with beyond just this conversation. And so I think that's a challenge for everyone that's put in this situation. How do you approach it in a constructive way that doesn't burn a bridge, basically?
I'm sorry.
I just want to expound on that. I said how biases are prejudices, right, that people have against other people, but there's also preferences. So it's preference or prejudice. So I want to share a story where it's actually the flip side of it, where it's actually a preference. Preference, the bias was actually a preference. So I do criminal defense in Monroe County, and I'm probably the only male attorney of color in my county, and I'm also the probably least experienced criminal defense attorney in my county. But I kind of stick out when I walk into court. I kind of stick out like a sore thumb. So I've had at least 3 occasions in the past. I've been practicing now criminal defense probably for about 7 months. And I've had 3 occasions where I've either walked out of court or walked down the road by the courthouse, and someone said, "Hey, you're an attorney?" I'm like, "Yeah." They're like, "Oh, I want a black attorney. I want you." And I was just like, you don't even know me. Like, you didn't research me. You don't know that I'm the least experienced criminal defense attorney. So that's a preference. So there's biases that work on the other side of it. Like, someone will have a preference to you just because of your ethnicity or what they think. Not even looking at your looking at your biography, whether or not doing any research. So I had to me like 3 weeks ago. I was walking past someone's office. They walked out of another attorney's office. They're like, "You're an attorney? Can I get a card? Because I want a black attorney." I was just like, "All right." Well, you're practicing for 7 months, but so like I said, it's both sides, preferences or prejudice.
So to keep it moving forward, so we just kind of, what kind of biases do people see in that vignette? We sort of talked about our own experiences. Can anyone?
Age bias.
Mm-hmm. Gender, yeah, the young lady comment.
Geographic.
Yeah. So these are the biases we saw. We're going to loop back into this closer at the end, I think, after Sharon goes through it. But confirmation bias, affinity, attendance, attribution. I mean, I think you all saw, it was clearly meant to evoke a response from all of you. And so that's why we wanted to do it, so you guys could see it in live action. And we also were actors on the side, so we just wanted to. All right,
good ones, too.
Making about -$10 a day. So. All right, so we're going to turn it over for the third portion.
Okay. So hi everyone, I'm Sharon Harney. I'm local. I'm here in Center County, Zone 11. And I'm here to talk about how you get your ethics credit today, which is talking about the Code of Civility and the Rules of Professional Conduct. Go back to reading your emails, I guess, at this point. No, this is really important. And even though whenever we talk about rules, Code of Civility, things like that, I know it can get tedious, but it's actually important in this context because we're talking about the future of our profession and what are we going to do as young lawyers and leaders in moving our profession forward. So this is, you have the Code of Civility in your written materials, and we decided to focus on 3 of those specific paragraphs, 1, 5, and 7. We highlighted a specific portion in paragraph 7, which says a lawyer should refrain from acting upon or manifesting racial, gender, or other bias or prejudice towards any participant in the legal process. So breaking that down a little bit, the Code of Civility is aspirational, right? So all of them are shoulds. There's nothing mandated about it. And the specific paragraph related to racial, gender bias is towards any participant in the legal process. So it's, again, very narrow. Again, it's towards the Code of Civility for lawyers, and there's also, we had included the Code of Civility for judges as well, and there's similar language in there as well. Looking at the rules of professional conduct, Rule 1.3 says diligence. A lawyer shall act with reasonable diligence and promptness in representing a client. The comment to Rule 1.3 says that a lawyer must also act with commitment and dedication to the interests of the client and with zeal and advocacy upon the client's behalf. So how far does that go? And if you look a little bit further down the comment, it says specifically, the lawyer's duty to act with reasonable diligence does not require the use of offensive tactics or preclude the treating of all persons involved, again, in the legal process with courtesy and respect. So again, it says, just because you need to be a good advocate doesn't mean that you go over a certain line and you need to treat everyone in the legal process with courtesy and respect. There's also Rule 8.4, which focuses on misconduct. So it's professional misconduct for a lawyer to engage in conduct that is prejudicial to the administration of justice. Looking at that, and some comments to that, under comment 2, it says that although a lawyer is personally answerable to the entire criminal law, a lawyer should be professionally answerable only for offenses that indicate lack of those characteristics relevant to law practice. So comment 2, number 1, focuses on illegal conduct. So again, there has to be some sort of finding. It has to be against the law. And also it's about lack of characteristics that are relevant to law practice. When you look further into the comment, some of the examples that are given that would seem to indicate lack of characteristics relevant to law practice are those that include violence, dishonesty, breach of trust, or serious interference with the administration of justice that's connected to the practice of law. So are objectionable behaviors that are related to racial, gender, or other animus linked to the practice of the law? And if so, in what context could it potentially be linked to the practice of law? So the Pennsylvania Bar Association, the Pennsylvania Disciplinary Board, and the Pennsylvania Supreme Court are all exploring this right now. It's very highly relevant. So the Pennsylvania Bar Association, based off of the Women in the Profession Committee and the Legal Ethics and Professional Responsibility Committee, created a recommendation and a subsection G to Rule 8.4 that has this language that you see here. And this passed the House of Delegates unanimously in November of 2016, so less than 2 years ago. This kind of came up, and it was based off of the ABA adjusting their model rules around that same time. So it attempts to answer this question of what's considered professional misconduct. It's based off of, again, the ABA model rules saying that there had to have been some sort of conduct that the lawyer knows is harassment or discrimination based off of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status. I mean, they try to be really all-encompassing. I think it even goes beyond what some people may think about when they think about certain types of biases. Coincidentally, the Pennsylvania Disciplinary Board also had a proposed rule as well. And their proposed rule, and it came out actually 2 days before the House of Delegates voted on the Pennsylvania Bar Association's recommendation. So this proposed rule is more limiting. And this says that it's professional misconduct for a lawyer to violate a federal, state, or local statute or ordinance based off of race, sex, religion, national origin, disability, age, sexual orientation, or socioeconomic status by conduct that reflects adversely on a lawyer's fitness as a lawyer. So they tried to tie things in a little bit more narrowly, and they based their proposed rule off of an Illinois rule rather than the ABA model rule. So the Pennsylvania Bar Association saw this, and they decided to issue some comments, and they said, they wrote a letter back saying that we don't believe that this proposed rule that you have goes far enough. One of the issues was that you had to have an actual judicial finding that a lawyer broke a law related to discrimination. And when you think about that logistically, it could take years before you have a judicial or administrative agency finding the lawyer engaged in an illegal act that was based off of one of these biases. The other note was that many times cases involving discrimination settle, and so you never find out about it, and you never have a judicial finding at all. There are different standards of review for these civil cases, preponderance of the evidence versus clear and convincing, which is required for professional misconduct. So the Pennsylvania Disciplinary Board would have had to go through their own fact-finding anyway to meet their own standard. And so there were some issues, and plus there were also issues that it didn't include other types of protected classes that were included. So this sat actually for a little bit. It was kind of up in the air what would actually happen, but as recently as May 19th of this year, the Pennsylvania Supreme Court announced that they were proposing their own rule. And I apologize because it was so late breaking, we'd actually come up with these slides before we found out about the rule and the comment period. But their proposed rule states that is professional misconduct for a lawyer to, in the practice of law, by words or conduct, knowingly manifest bias or prejudice or engage in harassment, including but not limited to bias, prejudice, or harassment based upon race, sex, gender identity or expression, religion, national origin, ethnicity, disability, age, sexual orientation, marital status, social economic status, or political affiliation. They said except employment discrimination unless it results in a final agency or judicial determination. So there was like a carve out there that included the PHRC and the EEOC. And they gave examples in the comments of examples of manifestations of bias or prejudice include but not limited to epithets, slurs, demeaning nicknames, negative stereotyping, threatening, intimidating, hostile acts. Harassment is verbal or physical conduct that denigrates or shows hostility or aversion towards a person on these bases. Sexual harassment includes but is not limited to sexual advances, requests for sexual favors, etc. So that proposed rule is on the website. You can look at it. They had it open for comment until, I believe, June 18th. So it's closed for comment now. And we'll see what happens. This might actually be in our rules moving forward, and we have to be aware of what it means for us. And also, we have an obligation to note when we see it, what are we going to do about it within our profession. So, this guy. You thought you had enough of him, but we brought him back to the CLE. So, I use this example as an extreme example of how far our profession can go and what we can do or cannot do about it. So for those who do not know who Aaron Schlossberg is, he's a New York-based attorney. There was a viral video that went around where he berated during his lunch hour two employees who were speaking Spanish to another customer. He threatened to call Immigration and Customs Enforcement on them, alleging that they were illegal. And made all sorts of very harassing, threatening language. It was all caught on video. So the reason I bring it up is that a letter was sent to the New York Bar by some New York State representatives seeking professional discipline of him. And then there was this question of How far could the bar go? How far could the New York bar go? And we have it on video that everybody knows about with all the language. And frankly, under New York's rules, which are very similar to our rules, it's hard to see how he could be disciplined in some sort of way. He was doing it in his off time, he was making these comments in his off time. It wasn't related to the administration of justice. He wasn't representing these folks. They were third parties. And even if we found it reprehensible, what could the bar have done actually about it? And so it's this balance of First Amendment rights with professional obligations and where we want to move our profession forward. Lawyers are generally held to a higher standard. That's why we have rules of professional conduct. But we also have to keep in mind that even in extreme circumstances like this, we might not have a clear-cut solution. I'll talk a little bit about mitigating implicit bias, and you do have some of this information in the written materials because we are coming close to time, so I'm not going to go into this too much. But essentially, being aware, the fact that you all are here isn't a great first step. Once you are aware, how do you change your behavior? Think about shifting your perspective. Think about, frankly, we had a mindfulness CLE this morning, and trying to take better care of ourselves, because when we have a stressed brain, we make snap judgments a lot, and that feeds into implicit bias. Structural changes, as young lawyers, we might not have a lot of power in the institutions that we're a part of, including our places of employment, but there are things that we can start doing now. Are there ways that you can get involved in the Pennsylvania bar or county bars to move diversity initiatives forward, or to educate other people about implicit bias? And finally, accountability and transparency. Are there ways that you can help or bring up new ideas, even in terms of how billable assignments are allocated among associates? Is there something that you can help with there to ensure that everybody has a fair shot at things? So, revisiting the deposition, and again, I want to open this up a little bit. I know I threw a lot of the rules language and things out, but did anybody, we kind of debriefed a little bit about the deposition, but if you were in Jordan's shoes, was there something different that you would have done in that sort of situation?
Jordan, of course, not being Jordan.
Right.
Yes.
Yes.
To say only upon reflection, not necessarily in the moment,
Yeah.
but if you're noticing the deposition, you have every right to ask any question that is within that scope. And I can say, I get it, you're trying to help me out, but I'm going to proceed, this is my deposition. And if you really insist on that, just like if you threaten to call the judge, but I would just say, this is my deposition. I don't plan on asking anything that's not within the scope of this case, but it's my show, and I'm going to run it the way I want to.
I think I might, knowing now the rules of civility and also, the proposed rule, I might actually quote the rule. Especially if probably there's been prior communication that would give you some hint that jerk who doesn't want to be a jerk might be a jerk. Deposition. So coming prepared for that, along with the judge's chambers number, in case you need to move forward with the deposition, to her point.
I'm Kathleen Wilkinson. The Federal Courts Committee, in conjunction with the Civil Litigation Section, recently did a program a little bit along these lines at Skytop, and we did vignettes similar to this. And I'm thinking that we should add some more along this vein, but we did show outrageous behavior between the attorneys, and we emphasized that the courts are not going to tolerate bullying or anything other than complete civility. Judges don't want to get these type of calls. We also had judges on our panel who would comment about what their procedures were if something like this happened. Should you call them? Should you put the deposition on hold? So knowing your judge and not being afraid, no matter what jurisdiction you're in, knowing ahead of time what are the rules so that you could be prepared.
And I think in this situation, it's a little bit easier to be a little confrontational, right? Because it's opposing counsel. It sets it up nicely. I think it gets harder when it's your boss who's doing it,
Right.
Right? And then all of a sudden, it's a little bit of a different environment that you're kind of going to.
That'll be your next CLE, right?
Well, it's funny because you said there's a lot. We thought about a variety of different ways to display this because candidly, there's just so many ways to do it, and it's hard to pick the best way to sort of get a conversation going. So.
Kathleen, really quickly, to your point, actually, the first motion I ever worked on as an attorney, believe it or not, was in opposition to a motion for admission pro hoc vice. Only motion for pro hoc vice I've ever seen opposed in my entire career. This was the first thing I ever worked on. It was an attorney from California who I was working on a case with a senior associate and a partner. She had gone out to California for some depositions in the case, and this guy wanted to get admitted back here, and he was just an out-and-out, beyond Jim Smith, just an out-and-out juror. So move for pro hoc vice admission to the Eastern District of Pennsylvania. We opposed it, and the reason we could oppose it, and what the senior associate told me, and the tip she gave was on Karen's point, as uncomfortable as it is, it's got to get on the record. Get it on the record, because she got all the interactions on the record. We opposed the motion saying this guy's an out-and-out jerk, and the motion got denied. The guy was denied admission. So to that point, yes, get it on the record and quote the rule if you have to. But there's a hand over there.
Oh, and in addition, put on the record, because you can't see what was happening during this deposition, you're raising your voice, you're standing up. Because you were also, with your behavior, intimidating her. Whether you thought
That's a
you
good
intended
point,
that
yeah.
or not, get that put on the record.
There's a comment there that I interrupted, I'm sorry.
Yeah, this is apart from the vignette, but I was just thinking, like, hypothetically, what if a client goes to, like, a managing partner and says, I really just prefer male associates working on my case. So the lawyer can't engage in discrimination, but then the client has given them specific instructions, so, like, you know, that might dictate who they give the assignments to. Like, in that regard, is the lawyer violating this rule?
Yeah, I think it's up in the air a little bit. And I think it's also about having trusted communication with your colleagues or bosses who you work for. You'd hope that, you know, an attorney, your boss would help stick up for you.
Right.
I think
Not always the case.
it's a good point that everyone has to be aware of this and do things to change everyone's behavior. So if a client comes to a partner and says that, the partner should be saying, we don't follow it that way, that's not the way we view it, you get a team, the team is X, Y, or Z, these are the best attorneys to help you. And so it starts at every level, because you have to be aware of your own and then help other people to be aware so that they can also combat it, because you're gonna see it in everyday situations.
But to be clear, and I don't know if Jesse is still in the room, but the Women in the Profession report and recommendation, that was one of the scenarios that the new rule is supposed to address, to make it enforceable, so that the supervising attorney would say, I cannot do that. That's against our rules of professional conduct.
Yeah, because I've actually had this conversation with other attorneys, and some of them were like, no, the client dictates, like, the client calls the shots, they can, and I didn't think so under this new rule.
Well,
but-
the rule's not been adopted yet.
Right.
Hopefully.
You know, it's interesting, that actually did happen at my firm, and my firm now is majority female attorneys. So we had a client who called and they wanted one of the male attorneys to be their lead counsel. They would only talk to a male attorney, wouldn't even meet with the female attorney to sign him up. We told him he had to go. We weren't going to tolerate it, we weren't going to work with him. I mean, that's obviously a decision that was made firm-wide that we just won't handle, we won't deal with a client who has those types of attitudes. Because we all work on all cases together. So, and it did spark a conversation in our firm. And actually, I think it's made us a little bit better for it as well. Because now we have a more open discussion about even our own biases too. Because a lot of the male attorneys were like, well, why did that happen? What do you mean? You know, they don't realize that it happens every day. You know, I mean, I can only speak because I've experienced the bias against women. I mean, I've gone into judges and I've been asked if I was opposing counsel's client. I've been asked if I'm my client's wife. So it kind of started the conversation, and I think that those are really good ways to try to mitigate bias in your own firms and in your own lives, because examples like that should be brought up and they should be talked about among everybody. Because it does open everybody else's eyes. Not just the women were outraged by it, but the men were.